Illinois sanctuary state laws continue on in federal courts, with Governor J.B. Pritzker laying out what he has to say in response to the U.S. Department of Justice saying, hey, your sanctuary policies violate federal law and is unconstitutional. Welcome back. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and join us each and every weekday morning. So right after Pam Bondi became the U.S. Attorney General, she went and ultimately sued the state of Illinois over the state's sanctuary state policies. And those policies say police cannot communicate with federal law enforcement officials when it comes to immigration enforcement. Illinois has laws like that. Cook County has it. Chicago has it. So Pam Bondi sued the state of Illinois, Cook County, and Chicago. And the defendants here, the state of Illinois and these other governments, they made a motion to have the case dismissed from federal court, saying that they don't feel that it is unconstitutional to not use state resources for federal immigration law. Then the U.S. Department of Justice, as we were first to report here with the Center Square, filed their response, essentially pushing back on all of what the state said is why the case should be dismissed. Well, now we have a new filing here from the state, defendants' combined response to the United States motion to set the briefing schedule for its anticipated cross motion for summary judgment. So it's 5 pages long, and essentially what it spells out is J.B. Pritzker in his official capacity as governor, as well as Chicago mayor, the superintendent of Chicago police, Cook County and the county board commissioner, and the sheriff. They moved to dismiss the complaints, and the United States responded in opposition. The United States would also like to file a cross motion for summary judgment. Despite multiple requests, however, they say the United States refuses to answer the basic question of whether such a motion would rest on evidentiary materials not presently in the record. The communicative stance by the United States poses a problem for obvious reasons if the United States intends to move for summary judgment solely on the basis of memorandum it filed in opposition to the defendant's motion to dismiss, without submitting declarations or relying on other factual materials. Then defendants agree that it makes sense to brief the United States cross motion at an earlier junction in the case and concurrently with the various motions to dismiss. So it goes on there, and we're going to see a lot of this procedural wrangling in this case. And it's one reason why it's probably going to take a while for the challenge against Illinois' sanctuary state policies to actually advance and to have some finality. Maybe it won't even happen before the Trump administration finishes out its term. But you've also got amicus briefs that have been filed in this case, this coming from the Illinois Coalition for Immigrant and Refugee Rights, and they filed this 17-page document, and they obviously are siding with the state here, and they say through this lawsuit, the United States seeks to results that would unleash devastating consequences throughout Illinois. The U.S. government requests that this court invalidate city, county, and state laws that prevent local police from engaging in immigration enforcement, referred to throughout this brief as sanctuary laws. The local government defendants correctly argue the U.S. government's attempt to commandeer local law enforcement violates U.S. Constitution, but the relief request here isn't just unconstitutional. If this court accepts the U.S. government's legal position and requires local public safety officials to enforce federal immigration laws, immigrant communities will be forced into an impossible catch-22. People will risk deportation every time they seek medical care, enroll their children in school, shop for groceries, or report unlawful employment practices. As a result, the risk of public health crises will increase exponentially. Public education will be undermined, local economies will crumble, and employers who violate wage and hour laws and abuse their employees will escape accountability. So that is what the advocates for immigrant populations in Illinois essentially have to say in their opening to their amicus brief. This story will continue, and it's something that maybe the governor will be asked about this. He's got an event today in Springfield at the governor's mansion. So we'll try to get there and ask the governor his thoughts on the status of this sanctuary law challenge from the U.S. Department of Justice and why we need to have sanctuary laws. Is it as simple as saying that, hey, an immigrant community member can't go to law enforcement and say, hey, I've been a victim because, well, if they ask my immigration status and I say that I am not a citizen, are they going to have to report it to local law enforcement? But on the other side, you've got sheriffs saying they've got illegal aliens in their jail that they can't tell ICE about. So this is the argument, both sides of it. How this is going to be handled by the federal courts, we'll keep watching. But those are the latest filings in that case against Illinois' sanctuary state laws, and where this will end up, we'll be watching. It's right here, Illinois in Focus Daily. I'm Greg Bishop. Get the podcast where you get podcasts. Watch the live show weekday mornings. Been having a few blips and blurps. It just so happens to happen in the busiest week in months whenever they've got both the chambers of the State House in session. So who knows? We'll get that figured out, and that way the live show won't be all glitchy. But hey, the podcast is live to tape, so you get that uninterrupted. The segments we record live to tape, and that's why you should just go ahead and like, subscribe, and hit that notification bell with Illinois in Focus here on YouTube with the Center Square, and get the headlines in your inbox at thecentersquare.com.